be looking to tweak it in any kind of way, whether it's regarding the limitation of weeks of coverage or the amount of compensation that goes on with it. And then the second thing that we'll talk about in the morning very briefly is the status of the Unemployment Insurance Trust Fund, its healthiness, and what we need to do to make sure that it remains as healthy as it has been in the previous years. We're going to start the conversation this afternoon with a presentation from the National Conference of State Legislatures, and the program manager for employment, labor, and retirement is Mr. Josh Cunningham. He is joining us via Zoom. And Josh, we want to welcome you to Mississippi and to the Labor Committee.
Great, thank you so much for having me. Thank you, Mr. Chair. As the chair mentioned, my name is Josh Cunningham, and I work for the National Conference of State Legislatures, and I do hope that someday I can come visit Mississippi and speak with you all in person, but this format we'll have to do for now. Also, big shout out to your staff. They've been really helpful getting this all set up for me, so big kudos to them. So I work for the Employment, Labor, and Retirement Program at NCSL. And my work largely focuses on state actions around disability employment as well as workers' compensation. As you may already know, NCSL is a membership organization serving all state legislators and legislative staff. We are a bipartisan organization. We do not advocate or take positions on state policies or legislation. I'm not here to suggest you take any particular action relating to workers' compensation, but simply hope to inform you about some promising policy developments and examples from other states. Today, I will be discussing an issue that NCSL refers to as stay at work, return to work, as a strategy for your state's workers' compensation system. By system, I am referring to all the major stakeholders, including the injured or ill worker, employers, workers' compensation medical providers, the workers' comp insurers, as well as the state government and its regulators and administrators. The basic premise of kind of the stay at work, return to work idea is that injured or ill workers are generally better off in the workforce than not when medically safe. What this is not about is rushing an injured worker into a situation where their medical condition may worsen. But what this is about is ways states in the workers' comp system can treat both the medical condition and simultaneously help the worker regain a working function and potential, allowing them to either return to their previous employer, find new employment, or ideally never leave the workforce to begin with. And why is it important? Well, nationally, about 4.6 million workers are injured on the job each year, according to the National Safety Council. OSHA also reports that health-related work absences cost American businesses as much as $230 billion each year, including $60 billion in lost productivity. Various research studies have also found a link between the length of a health-related work absence and the likelihood of a worker rejoining the workforce. In other words, the longer someone is away from work, the less likely they are to ever return to work. One analysis from the Washington Department of Labor and Industries found that when a worker is away from work for a year, they have about a 32% chance of ever returning. And if that absence is 2 years, the chance they'll ever work again falls to just 5%. Now, to be fair, that's just one report from one state, so the specific numbers vary. But there are a number of other cities that have confirmed a similar link between the length of absence and the odds of returning to the workforce. And the takeaway is that time is of the essence. In that Washington report, even at 6 months, the chances of returning to work fell to 55%, and other cities have shown that number even lower. So this is critical considering the time to process a workers' comp claim, particularly if it has to go through an appeals process, can itself take a month or several months. So what are some of the benefits to this kind of employment-focused approach? Well, considering wage replacement benefits are through workers' comp are often only 2/3 of a worker's pre-injury income and are temporary, being able to return to gainful employment allows for more financial security. Research also shows that working in some capacity can actually speed up a person's recovery time. For employers, it's costly to lose or replace a skilled worker, and so there's an incentive there to retain injured workers when possible. And for state governments, the benefit, or there's a benefit as well, because returning folks to the workforce, number one, reduces demand on state services, and also adds to income tax revenues. So in a lot of ways, it's kind of a win-win for all parties. But what does this all kind of look like in practice? We kind of look at the state of Washington as somewhat of a model, and I'm going to get into why this program is a little bit difficult to replicate. But what they've done is they've created regional centers for occupational health, what they call regional centers for occupational health and education. We call them COHEs for short, COHE. These centers help coordinate among the various stakeholders. So they coordinate with the worker, the medical provider, the relevant state agencies, including their state vocational rehabilitation services, as well as the employer. They develop treatment plans that are tailored to each individual worker with a common goal among all the stakeholders of returning them to the workplace. When it is not viable for an injured worker to return to their previous employer, the COHE will help identify alternative employment options as well as opportunities for the workers to learn new skills. The COHE model has been highly effective at shortening the time injured workers are away from the workplace. Now, that being said, as I mentioned, there are some unique characteristics about Washington that make the COHE model difficult for other states to replicate. Foremost is the fact that Washington has no private workers' compensation insurance. They are one of, I believe, 4 states with a state-run workers' comp insurance system, so employers purchase their coverage through the state. This does give the state a lot of control over the insurance side of this, as far as what gets covered. And a lot of these states, these 4 states, offer things like premium discounts and other options that most states don't have the ability to offer. But while the Washington model is a bit difficult to replicate, there are some guiding principles that they use that I think are perhaps noteworthy to you all. Number one, their number one goal is efficiently managing workers' compensation insurance claims. In other words, they really focus on shortening the amount of time that it takes to process a claim. From the time that a worker is injured to the time that the claim is settled, and they have a treatment plan in place, and that worker can begin receiving their treatment. Shortening that time, again, because as I mentioned, time is of the essence. Number 2, they create treatment plans that outline an injured worker's abilities and work restrictions. So that's their second goal, really tailoring again to that individual worker's needs. And then number 3, they develop plans that overcome any barriers that might stand in the way of that injured worker returning to work, and really looking at what those barriers could be. It could be an educational barrier, it could be a specific accommodation, and what is our plan to overcome that barrier? So those are their 3 kind of guiding principles. Some other examples I want to mention from other states include your neighbors in Alabama. They have a program called Retaining a Valued Employee, or RAVE program, and that is actually run through their vocational rehabilitation services. But the RAVE program assists employers in retaining workers whose job duties, job performance, or promotional ability is affected by an injury, illness, or disability. And they actually, they serve workers whether the limitation occurred on the job or whether the injury occurred off the job. And in that program, a professional team comprised of a voc rehab counselor, a business relations consultant, and a rehabilitation engineer work directly with the employer and the employee to assess, identify, and provide needed consultations and other services that really help facilitate a successful return to work. Both the Washington and Alabama examples are examples of really looking at how do we not only bring stakeholders together, but really engage different agencies. And I mentioned, like in Washington, the rehab services coordinate with the workers' comp, and that's something that doesn't really happen in a lot of states. But in some ways, it makes sense that your vocational rehabilitation, who specializes in helping folks return to the workplace, would coordinate with your workers' comp services and help provide some of those services and expertise through that process. But a big challenge in states is kind of breaking down those barriers between those different agencies. Some other kind of policy examples I want to touch on are things like in North Carolina and Massachusetts, they have a trial return to work program. So for a lot of injured workers, there's a hesitation to return to work because they're afraid that it will take them off of their workers' comp benefits. particularly if they go back to work and maybe they realize they can't do it or they're not ready for that yet. There's a fear that they won't have benefits to go back to, so they won't even try to go to work in the first place. North Carolina and Massachusetts have created trial programs that give them a window of time, and where if their return to work isn't successful, they can return right back to the benefits that they were receiving before. Additionally, Oregon has something called an Employer at Injury Program, and I think a few other states have something similar. And these provide kind of incentives or supports to employers to offer temporary transitional work for injured workers as they recover. So in Oregon, employers can actually ask their workers' comp insurer to cover accommodation costs, provide partial wage subsidies, help cover expenses related to any sort of furthering educational materials or courses that a worker could take to kind of reskill themselves, and other expenses that would be associated with transitional work. The insurer then can request reimbursement from the state, and the way that's set up, it really takes the burden off the employer to have to front the upfront cost, and they can get that covered through their insurer instead of the insurer then again gets the reimbursement from the state. And again, the intent of this program is to really help the injured or ill worker remain connected to their workplace, even if it means performing some sort of alternative work or alternative duties. In closing, just to reiterate, the workers' compensation mechanism is a mechanism that states can use to help injured and ill workers return to the workplace. Extended absences from work due to injury often result in those workers never returning to work and leading them towards state and federal support programs that are notoriously very difficult to get off of. The stay at work, return to work concept is one that NCSL has been researching in coordination with state legislators and other policymakers across the country. In 2015, NCSL entered into a partnership with the U.S. Department of Labor, as well as the Council of State Governments, looking at this issue among other policy issues with the goal of helping states create employment opportunities for people with disabilities. That partnership, called the State Exchange on Employment and Disability, or SEED for short, continues today with additional partner organizations like the National Governors Association, the U.S. Conference of Mayors, and we help provide states with policy tools and resources they need to tackle these complex challenges. The SEED partnership recently published a Stay at Work, Return to Work policy toolkit that digs much deeper into this issue. I've mostly just kind of touched on the high points, and I certainly think I can speak on behalf of NCSL and SEED and say that we would love to continue working with this committee, working with the state of Mississippi going forward on this issue and kind of this unique approach to workers' compensation. And so with that, I thank you for your time and I'm happy to answer any questions you all might have.
Okay, Josh, thank you for that presentation. Just a couple of questions. You said that a lot of states take the approach that getting the workers back to work as soon as possible is in everybody's best interest. Is that correct?
Correct, yes.
And so a lot of these other states focus on training and retraining programs. If a worker can no longer do the kind of work that they were doing previously, there's an aggressive retraining program that's undertaken.
So correct. It's really a coordinated effort. And like I mentioned, in Washington, again, they have more control just based on the way their system is set up. And I don't advocate for whether you want to do private insurance or public insurance. That's not my place. But the way that they have their system set up with the state being essentially the insurer, it does give them a little bit more control over what they cover. So they can say, we're going to cover educational training or reskilling and other career development opportunities for these workers. It might be a little bit harder to coordinate that if you're working with private insurers. But that's kind of the premise, is that if we can't tell them to do it, we can maybe provide some sort of incentive, like in Oregon, provide some financial incentives through the state to help retrain and reskill these workers who, again, if you've suffered some sort of injury or disability now that completely changes prevent you from at all working the job that you were previously, how do we retrain you, develop new skills, help guide you down a path that allows you to continue working in some way?
Okay. And in your research, can you talk a little bit about what the average weekly compensation might be, and what the excuse me, what the duration of the compensation is in many states?
Sure. So I think it's pretty common that as far as wage, kind of the wage replacement benefit, the cash benefit, is pretty commonly about 2/3 of what your pre-injury income was. As far as the length, maximum lengths, that really varies across the states. I believe Mississippi is at 450 weeks, and I believe that's for all cases. Some states break it up based on the type of, or the severity of the injury. So if it's resulted in a permanent, like I believe Alabama, if it results in a permanent total disability, meaning that you cannot work again, then they provide, I believe, some sort of lifetime benefit. And in some states, I believe that they actually, in those situations, they'll come to some sort of settlement with the workers' comp insurer, where the insurance company will essentially pay out kind of a lump sum benefit. That way, it kind of ends the claim part of that, so that it's not this 50-year-long claim or whatever for the insurance company. But they'll work out some deal with the worker and a settlement on what that total lifetime cash benefit will be. But again, it really varies from state to state. Some states I think are at 500 weeks. Again, others it's unlimited if it's permanent disability, but if it's just a partial disability, which means that they can work somewhat, but are permanently have the disability, but kind of as a partial disability, then there's some different limits on that benefit, on how long. Usually that has some sort of time limit to it. And that would then also be adjusted by what are they earning, what is their earning capacity. A lot of this goes into calculations of what is a worker's potential earning capacity, if it's reduced from what it was before. But again, they can work some, then what is the difference between what we think they can make now and what they're making before, and we'll adjust our benefit based on that difference.
Okay. But you did mention, I want to make sure I heard you correctly, that in some states where there's been a permanent disability, where a person cannot work, they offer coverage and benefits for a lifetime?
Yeah, it's a lifetime benefit. Yeah.
Do you know any states in particular that offer that?
I believe Alabama does, and I haven't tracked it state by state. I did look up theirs just to get an example of one of your neighbors. But I can work on a list of that if you'd like, but I do know that there are several states that do offer that lifetime benefit. If it's a permanent total disability, the person does not have an earning capacity, for the rest of their life, essentially, is the determination that's made. And that's a determination that a doctor makes, usually after about a year, like a couple years of treatment. You reach a point where the doctor has to, usually the statute requires the doctor then to make a determination. How are we going to classify this particular claim? Are we going to classify it as they have some working capacity, or if the doctor feels that they don't have any working capacity at all, then they'll be identified as having this total permanent disability status, which then triggers the lifetime benefit.
Okay, thank you. Questions from members of the committee? All right, Josh, thank you so much. You're going to stick around for a few minutes. Someone may pop a question that they want to direct to you. So if you can hang around for a few minutes, we'd appreciate it.
Definitely, Mr. Chair, thank you. Not a problem at all.
Okay, thank you so much. All right, we're going to move right along, and we have with us the commissioner of, the chairman of the Commission of the Workers' Compensation Board, former representative, Mr. Mark Formby, and he's going to come in his own way. Mark, you could just sit right over here, make it less formal.
Thank you very much.
Unless you prefer to stand.
That's fine.
Okay.
I sit when I teach my Sunday school class, so this is more comfortable. So, is that too powerful? How's that? So, Mr. Chairman, thank you very much for giving me the opportunity to come and testify, discuss before the Labor Committee. You have asked me to start by doing something that I did before the the Senate Insurance Committee last week, so I will do that. Basically, the chairman asked that I give sort of a primer, an overview, because the one thing that I have found is that most of us, including many employers, don't have a really good grasp of what workers' comp is. I will also confess to the committee that I have with me today two of my attorneys. I have Senior Attorney Megan Garrett and Senior Attorney Jeff Skelton, who are here. And as we get into the depth of your questions, I asked them to be here so we could get them all answered, because I don't purport to understand the entire depth of the act and all the finer points of the code. I'm also here on behalf of the commission. The commission, I am the chairman of the commission. There are three of us. Beth Harkins Aldridge is one of the commissioners, and Mark Henry is the other. I'm here to represent the commission, and when we get into questions, I may give you some personal opinion. That would not be, that I would not say that was on behalf of the commission. And I will say the one thing that makes me different on that, Mr. Chairman, is that while some of my predecessors had personal opinions, they could keep them to themselves. After having spent 24 years in the House, most of my personal opinions have been recorded in the record. So it's hard for me to run from those. I will say, as we walk through this process, that I took an oath to uphold the Act and the Constitution. So regardless of my personal opinion on any matter today, the mission is to uphold the law. And I now have a 3.5-year record of hearing hundreds of oral arguments and signing off on, I think, a couple of thousand final settlements. And I hope that my actions have proven that I'm going to enforce the law that y'all pass. So generally speaking, and this is going to be just a quick overview, and then I'll take questions. Workers' comp itself, and I will say that I had members of both of these bodies at various times as I was carrying workers' comp legislation over the years that really thought, and I know that the senators that are here don't think this, but they really thought that workers' comp was a state insurance agency. And I was asked that a lot. It's not a state insurance agency. Workers' comp as a concept is a no-fault insurance protection for workers. It is sold on the open market, and employers are required to buy it. It's been around since 1948. In Mississippi, if you have 5 or more employees, in most instances, there are some exceptions, you have 5 or more employees, you're required to have it. Now, as we walk through this process, Chairman Horn had asked me to have my staff, and they've prepared y'all I think a 2-page information sheet that describes what some other states, not just our surrounding states, but other states are doing as far as benefits. We'll get into that at the proper time, but that is before you now, and those questions are sort of pre-answered. Workers' comp is designed to be a no-fault insurance. So originally to protect the worker and the employer equally, and it's designed so that if you get hurt at work and you're working for a workers' comp employee, then your injuries are covered, and all your health benefits are covered. Your salary benefits are covered. It covers occupational illnesses. It covers occupational diseases. It covers big and small injuries. It covers lifetime injuries. It will cover the retrofitting of a house or a van, if that's what's necessary, if it falls within your injury and is prescribed as a medical condition as it relates to your injury. It covers all medical bills, doctors, hospitals, nursing facilities, therapy, physical therapy, prosthetics, if we lead to that. So it's pretty broad. In Mississippi, we deal with 13,000 plus or minus injuries a year that actually get reported. Of those, 2,500 plus or minus, it's amazing how consistent it is, will actually be contested or controverted, and then those begin a path towards settlement.
Excuse me, Mark, what was that percentage again?
It's about 2,500, and again, that's plus or minus. Those are handled several ways, but ultimately the goal is to get those settled so that the worker gets what the worker is entitled to. Our mission by statute is to do that which is in the best interest of the claimant. So we certainly try to work in that direction. If a claimant has concerns, then they can start a process that will bring them before the commission. They can do that with an attorney or without. The vast majority that come before us have an attorney, and a few do not. I will say that I've kind of been blessed to appreciate the practitioners of workers' comp on both sides of this issue. We have some really quality attorneys in this state, and I think they all ultimately really do try to do the right thing. Sometimes the right thing, is a point of view, so you have to fight your way through that. I will also say that when we have a pro se claimant, the first thing that I say to them, and I think the other commissioners do, the first thing that I inform them is that they are not unrepresented claimants, that they are self-represented claimants. They are representing themselves, and I remind them that they could hire an attorney if they would like. I make sure that they tell me that they know they could have, and there have been occasions where going through the process of a settlement, I have told them, including as recently as last week, that we probably should not settle today, but that they should go and think about hiring an attorney. Certainly there are some people that just need that guidance, others that don't. When a case comes before us, before the Workers' Comp Act, the statute for settlement, if you can't get it figured out, then we have 8 judges. Your first stop in this process would be before one of those judges. Those judges have regional territory. There are 2 per region. The state's divided into 4 regions. They all kind of work the greater metro Jackson area just because of the population, but they actually work on the road. They go out and they hold hearings on the road. And so they ultimately will reach a settlement, and then if both sides agree that that's the best settlement, it's over. If they decide it's not, either side can then appeal that. When it's appealed, it comes before the full commission, the 3 of us. We sit as a judicial panel in an environment like this, and both sides present their cases, and then we ultimately decide that outcome. We decide them on a unanimous or a 2-to-3 vote. If we have a 2-to-3 vote, then we literally will draft a dissent. Whoever is the dissenting vote will draft that dissent.
You mean a 2 out of 3 vote?
2 out of 3. It takes two of the 3. And in most cases, vastly most cases, we reach a unanimous decision. I've been there three and a half years, and I think I've written 3 or 4 dissents. Megan actually writes them. She could probably tell you exactly how many I've written, but a few. If then the employer carrier or the claimant are not happy with the commission decision, they would appeal further up. That would actually go to the Supreme Court. The Supreme Court typically hands those workers' comp issues down to the Court of Appeals, and they then become the final stop in this path. So that's kind of the broad view. The Workers' Comp Commission itself is fourfold, and for you as legislators, it's important that you know this because you obviously oversee us. You pass the components of the act, but you also have constituent issues, and we get lots of calls from legislators on behalf of their constituents, and we try to obviously do what we can to facilitate those. But the broad scope of the commission's job is that we are regulators. We regulate mainly the self-insureds of the state, but because the Department of Insurance actually does the insurance companies, but we do the self-insureds. We should and could, and in some states they have a greater role in regulation of safety issues and things like that in actual employers. We don't have that kind of budget. We also, as a part of the act, we are in charge of medical cost containment. We have a one department, and that's their sole task, is to make sure that we give the best service that we can medically, but that we do it in a way that we don't let the medical costs run rampant. Because the way things work, if the way the market works in this environment, it's competitive by premium. So obviously we want to keep those expenditures under control while, again, doing what is in the best interest of the claimant. We, as a commission, as I mentioned, adjudicate cases, and then the chairman basically holds the gavel over those hearings, and then I have some additional administrative duties along with, we have an executive director who runs the building. So that's more of the day-to-day. Now, you also had asked me to discuss various issues the other day, and we provided this sheet. Would you like for me to touch on 2 or 3 of those, or would you like me to take them as questions? Go ahead and attack those. Right. So I will say this again. When I came to the Workers' Comp Commission, I came with a history. I had been tapped in about 1992 or 93 by the then Speaker, Ford, and the then Chairman of the Insurance Committee, which at that time was Chairman Stevens, to carry workers' comp legislation. And my dad was a contractor. I had been a carpenter in a prior life, so I had some feel for the term, but my true education became very focused on a number of very tight issues within the Act, and these were issues that were presented and promoted by both claimants' attorneys and defense attorneys, by carriers and employers, because my job was to look at all the bills that were filed and then make some decisions, or at least inform the committee. So that became my first introduction. As you know, I did that for 24 years, and when I became the expert in the House on workers' comp. Once I got over there, I found out that I was the expert on about 6% of the total act, because it's a pretty broad and encompassing act. But that's where it started. So one of the things that my appointing governor asked me to do specifically, he said, I want you to compare us to other states. I want you to look at the way the day-to-day administration is working, and I want you to make improvements where you can make improvements to make our workers' comp system better than our workers' comp system is. So we immediately began to look at administrative issues. We made some changes. I tried not to make changes for change's sake, but we did make some changes. There are a number of areas that I can't change without legislative action. And so one of the things that I did early is I asked all the judges. I asked actually on the attorney's communication site, I asked them, I asked employees, I asked employers and carriers to all start papering me with ideas. I mean, the best way to figure out what people are thinking is to get them to write it down, and I got lots of suggestions, some that I thought were doable, and some, obviously, because the legislation may or may not be, that would be up to y'all. Some of the things that have surfaced, and I'm going to close, Mr. Chairman, with the last one that I know you have 2 people testifying today, so I'll close with that one. But we had a bill that was filed last year that passed the House. It was not considered in the Senate. I think it was Senate Bill 2798 last year. It was House Bill 461. It asked for 4 or 5 little basic, what we think, I don't guess anything's little or basic in this world, but administrative sort of issues that we cannot do without without legislative action. I think that I know one of them sounds like it's not claimant friendly. It came to me to be claimant friendly, and that is that when we passed the 2012 legislation, we required that every workers' comp case have medical documentation. You know, you would think that would just make sense, but apparently that was not the law. It is now. We have a rule that actually says that has to be done in within a period of time. The problem is that we don't have anything in the act, anything in the code that gives us a hammer, so to speak. So if you don't turn that in, then your case stalls out. And a lot of this is more true for pro se claimants. If you have an attorney, this is not going to happen to you typically, because the attorneys are going to stay on top of it. And we have a couple of practitioners here, and they are right on top of it for their clients. But if you don't have an attorney, then this is one of those things that everybody can just be really quiet, and you wake up one day and the 2 years has come and gone, and your case is dead because the statute has a 2-year limitation. So what we've asked is and this is from us, we've asked to have permission, or actually asking y'all to mandate that we notify those claimants, and that we be given the authority to dismiss the case if they don't react. Now that sounds not claimant friendly, but the fact of the matter is, again, attorneys will know this. They get the information in. Pro se claimant then will understand that it's time to act, and so that's what we hope for with that. We also have asked that in a pro se claimant situation, specifically a self-represented claimant, and I mean when I say specifically, it's in the language that was drafted, that the employer be obligated, if they have an injured employee, and that would also be their carrier, that employer would be obligated to give that claimant notice before the 2-year statute ran. I think, again, the tendency is to just be quiet and let it happen. Most of the time when an employee is not asking for more medical or asking for help, most of the time they're done anyway. But this would be something on the employer side that would be helpful to those claimants that didn't have representation, so that they didn't let that statute get by. And there are ways that they can toll the statute if they need to do that. The third thing in that bill is really just something that almost every other state agency has and we don't, and that is to allow us some additional authority to electronically notify renewals, non-renewals, and cancellations of policies. We have finally incorporated some DocuSign digital signatures into our daily process, and that did not come easy, but we are there, and that's just a request to help us move into this century. The other issue that is big to us, and I know that even within your body there's mixed emotions about how to deal with this. I will confess that as a member of the House, I voted, it's on the record, I voted to take the workers' comp system out of the special fund status. When I voted for that bill, I voted to take just about everybody out. That's what we did. We had been sweeping bills every 5 or 6 years, and so we did that. I still stand by the fact that there are lots of situations, lots of agencies, sub-agencies, departments, however they're termed, that should not have special fund status because of where their money is generated. I do think that we are different, and I will make that argument over and over because I feel like that, and this year has been a really good example. We are not funded out of the general fund. We are funded by assessment, which means that those companies that we assess, very similar to the Banking Commission. The Banking Commission assesses the banks of Mississippi that they regulate, and then they use that money for their budget to go regulate those banks. They are still a special fund agency. Ours is even broader in that we assess the carriers, that we regulate, and then we use that money as our budget, which you still have to approve, by the way, to go and regulate those companies and run our agency. One of the huge difference between us and them is that 85% of the money that we collect are from out-of-state insurance companies. So only 15% of our budget even comes from in-state. So this year, when our budget was cut, and I'm not playing the request was cut game, when the actual budget was cut, there was a windfall that was handed out, but it was not to the taxpayers of Mississippi because they don't pay our budget. The windfall went to the companies that we regulate. There's so many of them that nobody got a big bump. They all got a little bit. We are already kind of in the middle of what our premiums are and assessments are. So we lost the budget money. The state of Mississippi gained nothing. The people that got the bump were not even in Mississippi, and so we're struggling trying to function. I will, as a caveat to that, I'll add that we are an agency that went from about 78 employees down to the high 50s. That makes us a fairly small agency. But during that process, the caseload did not change. So we have really, my predecessor and hopefully, my staff now, we're running lean and mean, and we really have trimmed. We've done exactly what I think you would want us to do. But then when you get down to that and you're running that kind of weekly budget, $300,000 or $400,000 cut out of a $5 million budget becomes a pretty good chunk. So as we get into the process, I would love to continue to advocate for us to be put back. And again, I think I can justify, based on the others that are still in the special fund, that we belong in that group instead of the group that we're in. One question that I was asked last time that I'll go ahead and answer is COVID cases. And you may have asked that question, Mr. Chairman. I called to get an update today, and they didn't have it ready for me when I left. But as of last week, we had 778 cases of people who had COVID that had filed. In your report, you will see, I think on the second page at the bottom, Megan has researched that to tell you exactly what other states have done regarding COVID. I will say that right now, the way the law is written in Mississippi, COVID is like many other communicable diseases. Unless you can prove that you got it at work, which would be a pretty good stump to jump, it would not be covered. And I'm not saying that with a period, because there may be the case that could. I mean, when they start coming to us, we'll deal with those one at a time. But generally, overall, it has that appearance. I think we have 5 or 6 on the docket for the ALJ, for the judges. So they will review those first, and we'll see what they do, and then they'll begin to work forward. So that's a good overview. The other question of the day is the public records issue, which y'all are, I think, has actually been in this committee last year. I know there are 2 people that are going to testify, but the chairman did ask me to give you an overview of that. I will say again, this is personal to me. This is not something that I knew prior to getting there. It's something that I found out after I was there. I will also say that among the practitioner attorneys, they are split. You'll hear from 2 of them today. I do kind of take a side, and I'm going to tell you why. But I also understand their points of view, their positions, and you're going to hear from 2 attorneys today that I think are 2 outstanding claimant attorneys in the state. They both do a great job. We just may have some disagreement on this. So here's what happened to me. And of course, if you've heard this, Mr. Chairman, in the other committee, but we do final settlements where we actually bring the pro se claimants in and we sit with them and we go through their case, and then we sign off on them as final closure on these settlements. We call them 9I settlements. I always say, as I mentioned earlier, you could have hired an attorney. You're representing yourself. If you think you need an attorney, you should hire an attorney. I always say that. And early on, like, the first month or so, somebody said something to the effect of, well, I didn't hire an attorney, but it wasn't from lack of being contacted or something to that effect. And I really just kind of let it go, but it bothered me, so I went and asked my counsel at that time how they knew. How does an attorney know that a worker was injured in the state of Mississippi if they're only reporting to us? Well, the answer was that we send the list out. Well, again, that's going to be up to y'all to decide, but it really, and I step on toes when I do this, and this is my personal opinion, but my personal opinion was that I would have thought that in this state, I found almost every other state. I think there's one other state that does something similar to this, that you would have the expectation, and that's the way I look at everything, that you would have the expectation that if you were at work and you got hurt and you went to the doctor and you filled out a form and you sent it to a state agency, my opinion would be that you would have the expectation that that would be between you and your doctor and your employer. Now, that's not the case. And I'm not going to do anything about it over there. I have people that say, well, you should try to do it by rule and you should do this. I'm not. That's a legislative decision. And as long as y'all agree that that's the way it should be, then we are going to continue to send that list out. And you'll hear from two attorneys, both of whom represent claimants, and you'll hear their opinions. And so you'll take those opinions and weigh them out. But I did step off into that, and it's no secret that that's where I've been. And again, I'm not saying that is the position of the commissioners or the commission, because our joint obligation between the three of us is to uphold the law. And the reason that we send this information out, is that we had nobody. I don't think anybody ever actually challenged us under the public records. We had prior legal counsel that just said this is a public record. And so that even makes it a bigger reason for why I wouldn't try to address it in-house, because even though it was not the attorneys we have now, our own staff said that. So that's I think a more oversight than you probably cared to hear. But that's where I am. I'd be glad to answer any questions, and I also intend to hang around and hear the other speakers say.
We appreciate your presentation, Mr. Chair, and I do notice that Commissioner Mark Henry with Workers' Comp has joined us. And Commissioner, if you have any comments you'd like to add to the Chairman? Okay, thanks so much. Mr. Chairman, how long has the $505.43 weekly benefit been in place? And also, how long has the maximum of 450 weeks been in place?
I think the 450 weeks is probably in the original statute, so 1948. The 505 it has been in effect since January of this year, because as the average weekly wage moves, that number moves.
It's sort of a COLA?
It goes up every year, correct. If the average weekly wage went down, that number would, but I don't think that's, I've got a list of 30 years, and it's gone up some every year.
Okay.
I think most of our benefits, Mr. Chairman, and again, y'all got a good comparison of what we do and what others do. I think most of our benefits are probably original to the statute.
Yeah, it looks as if, I think it was Tennessee might have a lower, well, the weeks are the same, but.
No, we're number 50. I think we are the lowest because we have the lowest average weekly wage. Several, and I think the gentleman in NCSL said this earlier, I think most states deal with average weekly wage. The next component is what percentage of that wage is paid. We pay 66 and 2/3. We pay 2/3. Right. So, and then of course we cap out at that. Other states, some on the sheet that you're looking at, cap out at 75%, 80%, some at 100, and there are a couple of on there that you will see that they cap at 110% of the average weekly wage.
Yeah, and Has there been any contemplation recently of taking a look at that maximum weekly benefit and raising it beyond the COLA adjustments?
Well, you know, I get a list every year of the legislation that's filed in the House and the Senate. I think there's legislation that's filed every year, Mr. Chairman, to affect that. And ultimately, of course, you know, it's the legislature that will make that decision along with the governor, I guess, if he signs it. So the short answer is that those benefits are challenged year in and year out. The bottom line for us is that we don't really have a dog in that hunt. We're going to do what you ask us to do.
So the assessments that you make to employers with more than 5 employees.
Yes, sir. To the insurers, to the insurers.
Right. So what is the healthiness of the fund that is created as a result of those assessments?
Well, you know, there is no fund created. What we're assessing them for is actually our budget. The individual insurance agencies are solvent based on their premiums and their revenues, and we obviously regulate those. And when one gets in trouble, we go after them.
So
But-
a lot of your revenue is generated from the insurance companies that are writing the coverage.
That's accurate. We assess them for our budget. They each have a percentage based, I think, on what they did last year. And Not yet. I think we will. But just to stay on that, I'll let you address that if you want to. But to stay on that for a moment, the way that works is that we submit an agency budget to y'all, and then you tell us what our budget is going to be. And then when you tell us what our budget is going to be, then we assess them based on that budget. So we don't assess them amount of money first and come to you and say, this is how much we've got. And that's the point I was making earlier. If you cut our budget, you do them a favor.
Right.
You don't really do the claimants or the carriers in the state a favor. Okay. So now, if you have an interest in the second injury fund, because there is a bill that deals with that, and if you have an interest at any time, then I'm going to let staff answer that just because she brought it up. But we'll be glad to do that.
Okay, we'll hear from her.
I thought you were talking about it because we do have one dedicated fund.
Now, what is the second injury fund?
So if you, in the second not had a leg from an employer would only pay. That fund is a dedicated.
I'm sorry, you said $500 in there.
They just picked that. There was no, they had to have a source. That's what they picked. We have asked for an increase in the last 2 years in that, which will,
In that fund, it says, you have to pay into it until. And then whenever. Bi-weekly from the commissions.
And in an attempt to maintain balance here, the legislature, because it is a constant battle to try to treat the employers and the claimants, in a fair manner. What this is an attempt to do is, if you hire somebody that had lost an eye, or let's say somebody lost an eye, that'd make them a pretty tough employee to hire if knowing that they lost the other eye was going to make them perm total. So instead of paying for their scheduled member, which would be an eye, now they're totally blind. So that employer and that carrier would be obligated for life if it were not for the duration, if it were not for the second injury fund. So, the eye's kind of dramatic, but that paints a pretty clear picture. But it'd be also true, if I lost an arm and it paid out 100%, you could still hire me knowing that if I lost my other arm, and these are pretty rare, obviously, but knowing that if I lost my other arm, you would be responsible for that arm, but the loss of a second arm would make me totally disabled, where it wouldn't have if it was the first arm, if that makes sense. So the purpose of the second injury fund is to limit the exposure of the employer, which is to the benefit of the injured employee, because he can now be hired without that risk.
So the second injury fund goes beyond the 450 weeks?
If you are given a permanent disability, it would still pay out the limit of the weeks, because now it is a perm total. But what the employer would not, he would not have to pay that. He would only pay the terms of a scheduled member, which, if it was another whole arm, would be 200 weeks. Another leg would be 175 weeks. So, an eye's 100, toes, fingers, all those things that are defined, that employer would only pay that amount, and then the second injury fund would pay the difference between that and the total 450 on a perm total.
Any questions of members of the committee? All right, Mr. Chairman, we appreciate you, and you said you're going to be able to stick around for a few minutes.
I'll stick around, and further, when y'all are no longer adjourned subject to call, and you finally sign die and go home, and you come back,
We're trying to figure out when
renewed.
that's going to be too.
When you come back renewed in January, I'd love to be an asset and be available if you need me.
Absolutely, we're sure you will be. Mr. Cunningham, you're free to stick around if you like, but if you've got other things you need to do, then feel free to log off. But you're more than welcome to stick around. All right.
Stick around.
Thank you. Now we're going to turn to Ms. Jaribu Hill. She is the director of the Mississippi Workers Center for Human Rights. She's also an attorney in the Mississippi Delta. And Ms. Hill, welcome to the committee, and we're anxious to hear what you have to say.
Thank you so much, Chairman Horn, for the invitation and giving us this platform to share our views and perspectives. Since 1996, the Mississippi Workers Center has been advocating for the rights and privileges and opportunities for low-wage workers in the state of Mississippi. Many of them are non-union, many of them are languishing in extreme poverty. Add to that the issue of workers' compensation and benefits for those who are injured on the job. You have the double complication of lost wages and having that individual family member, head of household, breadwinner, if you will, be no longer able to provide for his or her family. We are very, very concerned about this issue. We've been advocating since 1999. Although we were formed in 96, we started running our 450 Weeks Is Not Enough campaign in 1999, advocating for an increase in the amount of benefits that are afforded injured workers who receive workers' compensation. And that, as all of my colleagues have spoken to already, is 450 weeks. And we've been advocating for an increase of at least 520 weeks for all injured workers who are eligible for workers' compensation. But more importantly, we've been advocating for full, permanent, uncapped benefits for those who are considered permanently injured. And those injuries, those types of illnesses have been described in previous hearings, and we also have shared information with you, Mr. Chair, and others regarding a report that was done in partnership with the Mississippi Workers Center for Human Rights in 2018 by the National Employment Law Project called Dying on the Job in Mississippi, where we do address some of the most severe forms of injury and fatality that is seen in our state. Thousands, as has already been stated, thousands are injured every year and hundreds die on the job trying to make a living. The low wages that are particularly the history and experience of most workers in the state is also one of those things that complicates the issue even more. Not really making enough to feed your family in the first place, and then after the 450 weeks, thrust deeper into poverty because there's absolutely nothing available for you at that point. So we are advocating that Mississippi join other states around the country in lifting the cap on benefits for permanently injured workers. And I can describe for you a few of those types of injuries that would render someone unable to work. Of course, permanent blindness, likely caused by a chemical spill or some particle flying up into one's eyes while working, nerve damage, which can be caused from working hydraulic systems and machines, jackhammers and the like, and amputations, as well as permanent paralysis from falls that have happened as a result of faulty scaffolding units and other hazards. These are all preventable hazards if the workplaces are made safer, if workplaces adhere to OSHA's mandate, which we call the preamble, but it's actually the general duty clause that all employers must provide a free and safe employment opportunity free from recognizable hazards. And we know that those are recognizable hazards. Those recognizable hazards include some of the things that I just described, as well as other things like stress and some of the invisible recognizable hazards that we know workers are exposed to on the job, including breathing in harmful chemicals that cause a variety of respiratory ailments and also can cause and do cause cancer. So because of the fact that injuries are going to be with us, because hazards are going to be with us until there is a way to rid workplaces of hazards, even those that are preventable, we still see that many, many workers are victims of those hazards. As long as that's the case, we believe that there must be more protection and more coverage for injured workers. And so we're advocating and we're asking, as we have over many years, we are asking for additional weeks for all injured workers who are eligible for workers' compensation. And we're asking for permanent benefits, uncapped, for those who can no longer work because of a hazard that they became a victim of in the workplace. We're also asking, along with some of the conversation that's been had earlier where we talk about the maximum weekly amount, it is also instructive to know that the 505.43, the $505.43 that Mississippi provides is in fact the lowest in the nation. And so we would want our state to come up and to improve and to increase that benefit so that workers who are injured can take home a substantial increase than what they currently take home. The $505.43 is the maximum weekly amount. And of course, there are other states who have similar amounts, but Mississippi is among the states, roughly 16 to 20 states, who continue to cap benefits. Of course, our cap is lower than most, and it sort of, as someone has already said, it twins up with Tennessee that also provides the 450 weeks cap. We know that there are states right now in our union who do provide the full coverage for those who are permanently injured. We know that New York provides it. We know that Iowa provides it. And there are other states that provide much more coverage for those who are permanently injured and cannot ever work again. We'd like to see full transparency in terms of the data that is provided regarding injuries, illnesses, and fatalities. And we'd like Mississippi to be registered nationally so that that documentation can be available for the purposes of comparisons, but also for the purposes of advocating for more benefits. We believe that there must be stronger measures put in place to prevent occupational illnesses and diseases and injuries. And that way of providing that way of making sure that stronger measures are put in place can only come about if we have our own state expression of OSHA. We are one of the states that does not have an OSHA component that is considered a state agency. We only look to the federal agency, the OSHA agency itself, and if we had a state companion agency, that would go a long way in terms of providing oversight, in terms of ensuring enforcement, in terms of more timely inspections of workplaces where hazards abound. We also would like to see the establishment of a Department of Labor, because again, that oversight could in fact provide more protection for workers on the job, create and increase productivity, reduce the number of injuries and fatalities that we are seeing today. We know that thousands of workers are injured on the job in Mississippi. We also know that hundreds of workers die on the job. And as I've said before, without sounding more like a broken record than I usually sound like, we believe that most of these hazards are preventable with the proper oversight, with the proper enforcement, and a shift in the culture in terms of work, a shift in the culture that values the worker and provides the worker with a safe and healthy work environment free from recognizable and, in some cases, unrecognizable hazards. And so for us, we are very interested in being a resource. We have been around since December 30th, 1996, coming up on our 24th year. We do represent workers in a variety of legal actions, including discrimination, including workers' compensation, and other issues that profoundly impact those who are most vulnerable. And we would very much like to continue in the conversations. We'd like to be seen as a resource that operates on behalf of some of the most vulnerable workers in the state, some of the poorest workers in the state, some of the workers who would be those who would go pro se to try to represent themselves because they cannot afford lawyers. And so to that end, we would like to see a clinical opportunity for pro se litigants to be able to really understand the workers' compensation system and get some assistance, if you will, with filing their claims and seeing those claims through to completion. It would be a travesty of justice if a pro se litigant were denied simply because he or she did not understand the law, perhaps had somewhat of a literacy challenge, or just really did not have access to all of the information. So we join with others in wanting to see an opportunity for a pro se litigant component or pro se litigant unit in the Workers' Compensation Commission office to specifically support and provide that type of coverage for those who are not lawyered up, those who cannot afford legal advocacy or legal representation. I am also a member of the Access to Justice Commission, and this is an issue that I do plan to raise with them as well, as a way of looking at ways that pro se litigants who come before the Commission for relief can in fact get some clinical support prior to bringing their claims before the Commission. Just looking at my notes to make sure I haven't I have not left out anything that I wanted to say. I think I have covered everything that I came to say for right now. Of course, I'm open to questions, and I urge you to look at the link. I have shared that link on Facebook, but I will also get the contact information for the commission to share the link with you for the report that was done in partnership with the National Employment Law Project that even in more detail explains why the need is so great and why Mississippi workers need more coverage. And Chairman Foreman and Formby and others have said there are challenges every year. And we certainly appreciate the legislators who bring up the issue of more workers' compensation benefits, who bring up issues that will provide more protection for those who right now have very little protection in the way of coverage once they are injured on the job. And of course, our continuous slogan is that no one should have to be injured or die on the job to make a living. So we believe that prophylactic measures must be taken to provide safer work environments. And if we had a Mississippi expression of OSHA, we believe that would go a long way in providing that type of oversight and ensure greater accountability. Thank you so much, Chairman Horn, for inviting me back to speak to the committee. And of course, I'm available for questions and would love to continue listening to the rest of the conversation. And thank you for making this Zoom opportunity available for someone who is in a very vulnerable spot in terms of having two of the illnesses that are chronic enough to make me vulnerable to COVID. So thank you so much for providing this Zoom opportunity.
You're quite welcome. And could you give us the name of that report again?
Yes, Dying on the Job in Mississippi. And it was produced by the National Employment Law Project at the request of the Mississippi Workers Center for Human Rights. We provided worker stories and some of the statistical information that was used in the report as well.
So can you tell us how many workers on average are permanently disabled on an annual basis in Mississippi?
Okay. I do not have the figures in terms of the number of workers that are permanently disabled. I can tell you that in reference to injuries overall, somewhere between 10 and 13,000. And for injured workers who die on the job, I can tell you that it's a little bit less than 200, perhaps 125 workers annually that lose their lives on the job. But I do not have the number of those who are permanently disabled by work. That is something that we are happy to research.
Thank you. Also, you've mentioned that you advocate for increasing the 450 weeks up to 520 weeks for those who are injured on the job but who can return at some point. How did you arrive at the 520?
Well, basically, we knew that it was 450 weeks, and I actually had to be schooled and educated on the type of negotiation that's not in my wheelhouse as a lawyer, but not asking for the sun when you might only get the stars, so to speak. So we were advised by some folks who have been doing this work and some folks who've been advocating in the legislature around other workers' rights issues that the 520 weeks would be an increase that would not be so astronomical. It would even be seen as something incremental. And so we decided that an even 10 years of coverage would be a first step. In some ways, the same way that folks are looking at the fight for $15 an hour, of course, still is not a living wage, but it certainly gets us closer to a living wage than we've ever been before. So we saw it as an incremental step. We saw it as being substantial enough where workers could see that there is some additional coverage and protection. So that's how we arrived at the request for 520 weeks.
Thank you. And of course, for the permanently disabled, the permanently disabled, you're advocating for offering full benefits without any caps.
Yes, sir, and that is something that we are proud to say we have others who are interested in helping to at least put that issue forward in a more full and in a more substantial way with regard to just that particular window of coverage for those who are in that class of workers who actually are not able to work again. We have in the past had many productive conversations with organizations, including the Mississippi Manufacturers Association, who at one time did express concern for those who are permanently injured and even said that they would be willing to consider supporting legislation that would get us to the place where those who are permanently injured would have full and permanent uncapped coverage. So we are going to be back in talks with organizations like the Mississippi Manufacturers Association and other groups to try to really hammer out the details for what that could look like and try to really bolster our roster of advocates and supporters for at least getting uncapped benefits for permanently injured workers.
Thank you. And you said 16 to 20 states currently put a cap on benefits, but was it that the rest do not?
Yes, sir, that is correct.
Okay. All right. And you are advocating for a state version of OSHA as well as a state version of Department of Labor.
Yes, sir. And as you know, we do have one element, or I should say one component of the Department of Labor, which is wage and hour, but we do not have a full department. And we see that as something that would be important in terms of oversight and also helping to stem the tide with regard to worker mistreatment and disabilities and injuries.
Okay, thank you. Any questions from members of the committee? All right, Ms. Hill, thank you so much, and I'm sure we'll be hearing from you. I'd like to, I'm sorry, Senator Simmons.
Thank you, Mr. Chairman. I have a question. I heard you say that Mississippi has the lowest benefits. What is the average compensation across the nation?
Okay, I do not have the average compensation across the nation, but it ranges from $1,500 a week all the way down to $300 a week. I'm sorry, all the way down to $505 a week, which is what ours is. Alabama has 800 plus. I think Connecticut has somewhere around 1,300 a week. So we are at the very lowest end, and it ranges in average from the 505 that we provide all the way up to over 1,000 a week.
Thank you.
Other questions?
You.
Okay. Ms. Hill, we appreciate you, and we will be in touch with you as we go through this. I do have one final question. The chairman mentioned, Workers' Comp mentioned that there are 5 pending cases involving COVID claims. Have you, in your work, and since this pandemic began, run across people that whom you might consider having been exposed to COVID by virtue of being a first responder or on the front line of the fight against the pandemic?
Yes, sir. Thank you so much for the question. In fact, we do have, it has struck home with us personally. We have 2 of our board members of our nonprofit organization who were stricken with COVID, including one person and his spouse was stricken with COVID. That person is a health worker and contracted COVID in the health facility, the nursing home facility where he works. We also right now are privileged to be developing a case on behalf of a worker who was a CNA, certified nursing assistant, who contracted COVID as a result of being in contact with her husband, who subsequently died from COVID. And we are right now working with her because she was terminated from her job, and also her unemployment benefits have been challenged. We just recently represented her in an unemployment hearing to make sure that she kept her benefits, and we most likely will be going on to federal court to represent her on a COVID-related Americans with Disabilities discrimination lawsuit. So yes, we are seeing workers who are contracting the virus at work. We are seeing workers who are unprotected at work. We've been sounding the alarm here in the Mississippi Delta, in particular in Greenville, Mississippi, which is the hub of the Delta, where many of our members, and we have a workers circle that meets monthly, and they could share with you. We hope that you'll get a chance to talk with some of them at some point. They can tell you that if they're in food service, for example, they're a cashier at the Greenville Golf Course Club, for example, they are masked up, and so is every other employee, but the customers coming in are not required to wear masks, even with a city ordinance that says they have to. We see very little enforcement, and we see people being placed in harm's way in food servicing and food processing. Those are where you find the largest numbers of cases where people are, in fact, contracting COVID while working. And because many of these jobs are lower wage jobs without benefits and without job security, there are a number of workers who are classified as temporary workers who don't have the benefits or the job status to even bring some of the claims that other workers are able to bring. At least they think that they don't have the status, because many of them do not know their basic rights. So yes, and that was a long way. That's what you get for first asking a preacher's daughter and then a lawyer to answer a question, then she answers 50 questions. But yes, we are seeing cases where people are contracting COVID at work.
Thank you. Commissioner, any response to any of the things you heard just now? I'm sorry? Okay, thank you. All right, we're going to move toward the end of our presentations today. Commissioner mentioned that the public information aspect of the sharing of claimants' names and addresses who have filed a claim is something that they want to see limited. There are two attorneys here with us today who will address this issue from different perspectives. We're first going to hear from Mr. Steve Funderburg. He is with Funderburg, Sessoms, and Peterson Law Firm. Mr. Funderburg, if you come forward at this time.
Thank you, Mr. Chairman, committee. I'm too short to sit there. I'm not sure you would see me if I did. I am an attorney. In a prior life, I exclusively almost represented employers, self-insureds, and insurance carriers. Now I typically represent injured workers on a regular basis on workers' compensation claims. I'm going to be brief. You've heard a lot about the reality that Mississippi is 50th in compensation systems as far as what we pay and duration of payments. It's always interesting to me to say, why? You know, how did that happen? And the short answer is we were late to the game. They've had workers' compensation concepts in Europe since the 1800s, mid-1800s. Chancellor Otto von Bismarck was one of the first. It didn't work well in the United States when they first tried it. In America, they thought it was socialism or, God forbid, communism, and it was rejected pretty much out of hand. States here started passing workers' compensation laws in the 1920s. Mississippi, as you heard, was 1948. We were 10 years beyond the state before us, which was Arkansas. So we were dead last in passing a workers' compensation system here. Once we did it in 1948, left it alone for 30-plus years. We didn't have indexed benefits here. You heard the chairman talk about it's similar to a COLA, where it bumps up every year based on the state's average weekly wage. We didn't do that until 1981 here. So you're really talking about a gap behind the rest of the country, and you've seen the printout that staff council at the commission put together, which I looked at, and it's excellent, and it's kind of like my numbers. It's SEC oriented, so that it makes sense to us what the states around us are doing. And you can see how far behind Mississippi is regionally, much less nationally. We're 450 weeks, which is the lowest in the nation. There's 5 other states that are 500 weeks plus, and then you've got 43 states that have some variation of benefits paid out lifetime or work life to a retirement age. And some of that's nuanced because it's tied to significant catastrophic type injury, and most of those are tied to permanent total disabilities. But logically that makes sense. If you have a 21-year-old that's permanently and totally disabled, why would their benefits arbitrarily stop at 8.5 years? The concept of workers' compensation is the trade-off, that the injured worker gets some limited benefits and some medical treatment. The employers and their carriers bear that expense as the cost of doing business, and in exchange, they get total tort immunity, even from their own gross negligence. They cannot be sued, even if they're grossly negligent. They're absolutely protected. So they get that immunity for that injury forever. Why are the weeks limited to 8.5 years? If there's a death case, 8.5 years after the death, the wife and the children, no more benefits are being paid. So that's one of the interesting realities here in Mississippi, is how we sort of lapse behind everyone else, but also it's curious to me, year in, year out, right here at the legislature, as Chairman Formby said, legislation is introduced where people are crying out for workers' comp reform. And I shake my head and said, this is one of the best markets for employers and insurance carriers and self-insured there could be. They're paying less than anybody else. So that part, historically, I think, provides some context as to how we got here. Now, the question is, how long will we remain where we are before some attempt is made to at least have the benefit period extended to help the injured workers here? Chairman asked me to address the issue of the Freedom of Information Act, and the context there is the B3 first report of injury. There was some confusion I heard earlier that this is a one-page form. It's completed by the employers, and it's mandatory. It has to be completed. It's not a violation of HIPAA. It doesn't provide any confidential health information. It's sort of a name, rank, serial number, statistical data sheet that is required whenever there's a work injury, and it is filed with the State Workers' Compensation Commission. Now, to give you the historical background here, about 10 years ago, some enterprising young lawyers said, we can get the list of first reports of injuries from the Workers' Compensation Commission by making a Freedom of Information Act request, because it's a state government document. And when they got it, which costs a lot of money, by the way, you have to pay for it, like all FOIA requests, then they use that list as a database to then solicit potential injured workers. Now, hue and cry went up, and I'll be dead honest with you, I was one of them that went to the commission at that time and talked to the chairman that was there at the time and said, what gives? Why is the commission aiding and abetting this small group of lawyers to basically market themselves out here to injured Mississippians? And the commission looked at it, and we were told at the time they consulted with the Attorney General's office, and then the commission came back and said, look guys, this is an issue of transparency. We're a state agency. This is a state agency document. It's a mandatory state agency document. We use it to keep up with our statistics, and if a proper Freedom of Information Act request is made, we're going to comply. If you all don't like the marketing aspect of this, then you need to consult the State Bar Association. And we did. We went to the State Bar and said, is this legit? Can they do this? And the bar looked at it and said, lawyers, these are professional ethical guidelines. Here are the rules that deal with lawyer advertising and solicitation. If everybody is following these rules, they're compliant. And one of those rules is that the envelope that this mail out or flyer comes in says solicitation material enclosed. So that, like a lot of you I'm sure do, you can take it out of the mailbox, look at it, and chuck it in the trash and never even open it. The bar said if they do open it, every word in it must be true. And if there's a free consultation offered, you better answer their questions for free and accurately if you're going to do it, or you're in violation. Well, at that point, the commission said transparency. The bar said if they're following the rules, it's ethical. So it became a, if you want to do it, you can do it and spend the money. If you don't, you needn't. Now, if you look at the Workers' Compensation Commission webpage, you will see that comp is very much statistically repetitive. You heard the chairman say earlier that there's, 10 to 13,000 claims. Well, for the last 10 years, it's really been between 10,000 and 11,000 injury claims in Mississippi, which is a testament to safety programs. It used to be 16,000, 17,000 back in the 1990s, but it's come way down. But of those, it's about 2,600, 2,700 litigated cases over the past 10 years. Now that's significant, and you can check the data. I'm not going to bore you with year-by-year analysis, but those annual reports are very detailed, available on the commission website, and are very useful to show how these injuries break down. The salient point here, 24% of these comp injuries are going to be litigated year in, year out. It fluctuates up to 25% or goes down to 23%. Year in, year out, about 24% is going to end up in litigation. The reason I think that's significant is the mail-out procedure that the chairman mentioned earlier and that Mr. Darby is going to speak to in opposition, I believe, has not increased litigation. It's remained flat over at least the past decade. So my firm began sending out informational material to injured workers in response of, it's been years and years now, so tens of thousands probably. We don't get any phone calls complaining. We don't have injured workers calling saying, how did you contact me? How dare you contact me? We get folks calling saying, I've got some questions, can I ask them? 70, 80% of the folks don't need a lawyer. They just had a couple questions. Some of them do. I had a young man fell 4 floors down, broke his jaw to pieces, broken ribs, broken legs, dislocated ankle, bad shape, lots of medical treatment, back at work. Called me with one question. He said they're offering $17,000 for full and final settlement, medical, everything for lifetime. Is that fair? And I said, no, that's not. You need to talk to somebody. So occasionally they do need a lawyer. But my point to all of this is the remedy that has been recommended is that the commission shield first reports of injury from a public record request. Now, these forms are used for lots of purposes by a lot of different people. So if the injured workers aren't calling and complaining, and I doubt they're calling senators or members of the legislature calling saying, all these lawyers are really bugging us, we need you to please do something. I doubt that's how this came on the radar. So the ox being gored here is what? Well, it's a small group of an even smaller group of claimant attorneys who don't like the practice. So anecdotally, you hear, as Chairman Formby said, that occasionally somebody will say, well, it's not for lack of these lawyers contacting me. And I've heard that several times. But if we're only talking about 2,500 cases in the entire state that are litigated each year, we're talking about a much, much smaller subset of people who are complaining. And even among the claimant bar, you've got attorneys who are in favor of it, offering it to injured Mississippians, and some opposed. Well, what's changed really in the last 10 years? I can tell you from my standpoint that swung the needle, competition. Morgan & Morgan, dominating television, radio, billboards, smoke signals, mental telepathy, whatever else they can use to hire folks, they're doing it, and you hear it every day. Brother Swartz is out there doing it every day. Small market Mississippi firms can't compete with that kind of advertising budget. So one of the few things we have is the ability to offer and mark, informational material in case an injured Mississippian wants to hire a Mississippi lawyer. So it matters very much to us. To me, the remedy that is suggested, that we're going to chip away at transparency of a state agency and shield a public record from production, is way, way, way too much. You're talking about a small group of people wanting to kill the cow because they're lactose intolerant. That's not the right remedy. You know, that cow's pretty useful to a whole lot of other people, and it shouldn't go away. So I'm happy to answer any questions about either of the issues I spoke on, Mr. Chairman.
Okay. All right. Thank you, Mr. Funderburg, and I have a couple of questions. So the first report of injury is a required form that is required by state law,
Yes, sir.
and it is a means by which the commission itself can keep track of injuries and so forth. And there have been opinions, I would assume, rendered by the Attorney General's office that says that it complies with the Freedom of Information Act, and is a public agency document, and therefore is subject to the public records law. Is that right?
The first part, absolutely. It's a required document. The commission uses it. Employers use it as well, because anybody that wants to make a request can find out if this particular worker's had other claims or this particular employer, has had claims. We were told contemporaneously, and this is about 8 or 9 years ago, that the commission had consulted with the AG's office. I never saw an AG opinion,
Okay.
But that's what we were told.
But you also said likewise that the state bar was consulted from the information you've received about the issue, and so long as it's factual, truthful, it says you spell out it's a solicitation and so forth, and if the advice is given free of charge, then it's in compliance.
Correct.
Well, so you mentioned, you said something that really piqued my interest, that year in, year out, the number of cases that are litigated is about 25%. So the request for this information has not prompted any increase in litigation.
Not in litigation. Now, I've heard, again, anecdotally, I've heard on the employer and the insurance company side of the equation where they say that their claim experience and the cost of claims has increased. And I said, well, that's true, but so has the cost of health coverage. Medical expense has gone astronomical in the past 20 years. So I'm quite certain that the cost of workers' compensation claims has gone up, just like health insurance and everything else. But to somehow twist that and tie it to a mail-out to injured workers, I think is misrepresentative.
Questions from members of the committee? Mr. Funderburg, thank you so much. We expect to be talking with you in the future about this and other issues.
Thank you.
All right, our final presenter this afternoon is Mr. Michael W. Darby. Mr. Darby owns Darby Law Firm out of Batesville, Mississippi, and he has probably driven the farthest to get here, so we appreciate your coming down.
Thank you, Chairman. Thank you for having me. I appreciate everyone for indulging me. The only Zoom I'm good at was zooming down the interstate to get here, so I try to get here as quick as I could. Anyway, I like to do things in person. Me and Steve go way back. He's a friend. I consider him a friend, but we have a significant difference of opinion on this issue. First, I think you need to know a little bit about my background before I get into why I believe what I believe. Mr. Chairman, my firm was just started. Unfortunately, my mentor and friend passed away last month, and some of you may know him as Charlie Baglin. I don't know. But as the older generation would know Charlie, as he was the chief of staff of Governor Cliff Finch. And if there was anybody that was a working man's governor, it was Governor Cliff Finch. And Charlie took that and instilled that in himself and instilled that in me. So if I felt this was to be beneficial to the working man, I'd be here all in support of it. but I do not believe this to be beneficial to the working man. You know, a lot of this will be anecdotal, like he said before. I've talked with adjusters and defense lawyers, and let me back up. I had a meeting back in March with Governor Hoseman's office when we were trying to push this legislation through, and one of the things that Mr. Funderburg can't say is we had bipartisan support. Not political support, but bipartisan in that we had defense attorneys, we had plaintiff attorneys. In the office, with the governor's office, we had people of both sides of the aisle supporting this legislation. What we're looking at is we're dealing with these adjusters on these claims. And now, let me back up and say this, I don't deal with adjusters anymore. Why? I have to file for lack of better words, a lawsuit. It's called a B-511, but just think of it as a lawsuit on every case that walks through my door. To keep the lawyers, you're going to hear me reference them as the Jackson lawyers because Mr. Skelton's here. He may could inform me if there's any lawyers outside of Jackson that does this, from sending these mass mailings throughout the state to my clients and individuals from Corinth to Biloxi to Natchez to Tunica. And so I file a petition as soon as my client walks through the door. Now, Mr. Funderburg indicated that he doesn't have any complaints. Well, I guess not. They're coming to him because of those mailings. Some of them are. I have plenty of those complaints. They come into my office. Michael, how did they get my private information? How do they know my name? How do they know where I live? What's to keep them from getting my social security number? What's to keep them from stealing my identity? Those are valid considerations for my clientele. And excuse me, I'm very loud, so I apologize for that, senators. But those are considerations that they have and concerns that they have when dealing with these cases. I had a guy that I've known since high school. I tell folks I'm from Batesville, but I'm really from a little town called Pope. If you go up the interstate, you'll know where Pope is, but I'm live in Batesville now. And I went to high school with this guy, and he comes to me, and he'd had a different firm, I'm not going to mention the name, and discharged that firm and come to me and said, you know anybody that does this? I said, well, yeah, I've done this for 20 years. Well, I didn't know. I got all these mailings. I thought these were the experts in the field. So, you know, that's just a problem that we don't need right now. I did want to reference, and forgive me because I didn't bring the printout, so I've got it on my phone. You know, one of the things that the other side doesn't want to take into account is there's a statute on this. There is a statute that says you cannot do this, 71-363 subsection 2. It states in pertinent part, and forgive me because I can't see, any person who receives any fee, other consideration, or any gratuity on account of services so rendered, unless such gratuity is approved by the commission or such court, and who makes it a business to solicit employment for a lawyer or for himself in any respect or award for compensation shall be guilty of a misdemeanor. Mr. Funderburg just admitted to committing a misdemeanor in here today. He basically said, we solicit this, we send this, and it's got to say solicitation material. He basically said, we're doing this for competition purposes. That's a violation of that statute. And so when I say we, I would disagree with Mr. Funderburg. I believe the majority of the claimant bar is totally against this. And, you know, I'm not going to put this in the Republican-Democrat viewpoint, but in the most part, claimants' attorneys usually lean to the left and defense attorneys usually lean to the right. It's amazing there's so many claimants' attorneys who usually lean to the left are in agreement with the defense attorneys that lean to the right. Why? Because it's the right thing to do. How can you say on the one hand, hey, we're going to make an exception, Mississippi Code section 2561-11.1. We're going to make an exception to exclude the name, home address, and any telephone number or private information of any person who possesses a weapon permit under this code. We can exclude them, but you get hurt at work and you've got this injury listed and that injury listed, medical information listed, hey, but let's just pass it out. Let's pass all that out. What's to stop me if I'm going to go down this path? University Medical Center, that's a state agency. Why can't I now subpoena public records from University Medical Center and say, provide me a list of all individuals that were involved in a car wreck. What's to stop that? It's where do we stop? Where does this end? I understand his concerns about the big giants of Morgan and Morgan, but I am a small town firm in Batesville, Mississippi. I'm going to mention lawyers' names who don't care that I mention it. Al Chaddick, who's in Kosciuszko, Mississippi. Shane Tompkins, who's in Columbus, Mississippi. Keith Carlton, who's in Corinth, Mississippi. John Ball, who's in Natchez, Mississippi. How are we supposed to compete with these Jackson lawyers sending these things out over and over and over? That's not really your concern, and I get that, but what is this legislator's concern is the private information of these individuals. At some point, enough is enough, and we're at that point. We do not need to let this continue. If we're going to let people with weapons permits information be excluded, why in the good Lord's name do we have to prevent, why do we have to get this information for people hurt at work? Why? It's for economic reasons, and you heard it. He admitted to that. It's economic reasons. It's not about the best interest of the claimant. There's no way on earth. Claimants in this state know that they can find representation. And Mr. Funderburg, to his credit, didn't bring this up as an excuse to you that, hey, we need to inform these people. We need to let them know that they're with their rights. Well, everyone knows at this point. We're in 2020. We have to have, there's laws there that say you got to have this form, this poster saying what you got. And if you can't ride up and down the interstate and see a poster board or a lawyer or something, I don't know what to tell you. But that's not going to change anything. I'm asking that we, at this point, do what's the right thing, and the right thing is to exclude this information. One other point that I'd make is those B3 forms have to be turned in, and there are, I haven't checked with Mr. Skelton or the commission on statistical running of these agencies that may do some statistics. I understand the need for that. But there's ways to exclude personal information, name, address, phone numbers. There's ways to do that. So at this time, senators, I'm asking that you consider, this is your all's decision. Ultimately, it passed the House. It's in the Senate. It made it through the Insurance Committee, as I understand, and this was the committee where it stopped at. And so this is y'all's decision on what to do at this point, and that's my story, and I'm sticking to it. So any questions, I'll be glad to answer.
All right, thank you, Mr. Darby. A couple of questions. So why wouldn't the Workers' Compensation Commission cite 71361 as a reason to not submit the information to these solicitors?
Chairman, I have brought that to their attention. I know that was something that may have been under consideration, but as my understanding was, legislation was probably going to be the easiest and cleanest way to stop this, because I suspect you're going to be dealing with some attorneys in Jackson that this is it for them, and I suspect that they would have been in court fighting that. Just in case you haven't seen, here's one of them. These are the folders that are going to my clients, okay? These are what's going to them, but I suspect that they know the commission doesn't have the time or the resources. They only have 2 staff attorneys. They can't be stuck in Chancery Court or Circuit Court or wherever fighting that on an endless basis. So that's my guess. I would let the chairman answer that, though.
And how would you answer the argument that there's no HIPAA-related information that's transferred in the course of this information being provided? Is name, address, or is it name, address, and phone number? That's it. That's being sent out. Am I correct?
Well, to be frank with you, because I refuse to do any of that. I've never actually laid eyes on the actual form that they get. But when you have a workers' comp injury, that means somebody's gotten hurt. That is a medical issue. I can't tell you that it's listed in that form or not. I would rely on Mr. Skelton or the chairman to answer that. But it implies that there is a medical issue, and to me, that is a HIPAA violation. You're talking about someone's medical care at that point, and so that's where I would be.
Okay, and one final question. To use the old euphemism, if you can't beat them, join them. Why wouldn't other attorneys just get in line and say, look, send me that list too. I want that list as well.
I'm not going to, Chairman, I'm not going to go with the motives of the people that do that. Like I said, Mr. Funderburg is my friend. I've had attorneys that do it now that would say that, you know, I would support you, Michael, if we get it stopped. But I had to do it. I couldn't beat them, so I had to join them. My personal view, Chairman, I grew up on a farm. I'll go back to cotton farming before I start soliciting people like that, because I just don't think it's right. And so that's my personal view. I know I can speak on a few attorneys who share that similar view, so that's kind of where I'm at.
Okay. Any questions from members of the committee? No. Chairman, you have any final comments that you'd like to make on this issue before we wrap up?
I don't really have any comments I'd like to make. You've heard the question, I'd be glad to answer that. My comments, I picked a side. That's my personal view.
Any questions? All right. Well, we've had a very lively discussion on a number of different issues. I want to thank the presenters because I learned something, and I think most members of the committee also learned some things from each of the presenters today. And we expect that we'll be trying to address some of the myriad issues that have come up today, including this freedom of information issue, but also some of the points that were made by Ms. Hill with regard to OSHA and Department of Labor certainly is worthy of our consideration. And also in terms of listening to the chairman, the issues of the special fund status for this agency is something of great interest. I think that we have adopted some of the things that he mentioned with regard to the notification before the 2-year deadline, that the deadline was coming up by employers, and electronic notification of the potential lapsing of coverage or the ability to file something I think we've already done, but in the coming session, I expect that we'll try to deal with these issues, including the issue that was last discussed at the hearing today. We're going to come back tomorrow. The Unemployment Insurance Trust Fund is weakening. I won't say that it's busted, because I don't think that it is, but certainly weakening with the impact of COVID-19 payments to folks who were put out of work by the pandemic. So we're going to hear from Ms. Turner tomorrow, head of employment security, on this issue. She's also going to talk about the minimum wage a little bit and give the agency perspective on that. And we will reconvene tomorrow at 9 o'clock, and she is our only presenter, so we won't be in here very long. So at this point, we will stand in recess until 9 a.m.